And I hate to do this to you, but I think it's time for rebuttal, but I'll really do my best to keep it brief. But just to respond to some of the questions raised earlier, I'll recall Mr. Pitcher first. Okay, thank you. I'm sorry. Mr. Pitcher, do you know what the elevation of the proposed site where the tower would be located is on the plan?
The AMSL elevation is 1118.
Is that elevation within the floodplain designation?
No, it is not. Even for the assistant, the city engineer, his comment was the flood elevation going across Market Avenue was 11 to 14.
Just so our record is perfectly clear on the adjustments to the tower location, am I correct in understanding that the tower was moved off of the south line approximately 10 feet, correct?
Correct.
To conform to the local ordinance?
Correct.
And at the same time that change was made to the plan, the height of the tower was also reduced by 10 feet, correct? To coincide with what would be the distance of that tower from any proposed development or expansion of the church.
Correct.
There is, sir, as I understood your testimony earlier, a fence that's around this entire enclosure, is that right?
That is correct, 8 foot in height.
Will that be locked?
Yes, it will.
Those are all the additional questions I have for Mr. Pitcher. Mr. Chairman, I trust you.
Yes, what is the height of the street lights in the parking lot?
I don't have an exact height. I approximated that at about 40 to 45 feet.
Sir, I had a question for you, and it is in relation to what Mr. Mack had discussed about the requirement to co-locate an antenna. So I guess I have to ask, is it feasible to place an antenna on the water tower, with the Brentwood water tower? Is it feasible to place an antenna there to resolve this what you allege is a gap in coverage?
Structurally feasible. Herein lies the problem. I'll take the date, September 11th, 2001. That is the date by which the entire wireless industry was no longer using water towers. Reason why? People in this country are extremely vigilant. Whenever they go on a tower or to be able to work on it, the public would notify the local cities and drive them completely nuts. That's one reason. The second reason is that all the cities that wanted to end up having antennas on water towers, they're interested in one thing, and it's a revenue-generating event. Little do they realize, though, they need to paint those towers every 7 to 10 years. That becomes an extremely difficult task when you have antennas on the tower, trying to have people working around them, or physically having to shut the cell site down so that they can work on the tower. What happens then? Your local police, your local fire, your safety forces who use those devices, those wireless devices through Verizon, will no longer have that service because they have to take that site down and off the air.
Jeff Wilson, attorney for First Friends, have a couple of follow-up questions for him relative to the antenna. How are you, sir?
Not bad. How are you doing tonight?
Doing well. So the antenna is going to be 10 feet above the cell phone tower, correct?
Pardon me?
The antenna will be an additional 10 feet.
No, that's not right.
So you have-
That's a lightning rod that's above the tower.
What is a lightning rod?
It physically, if there is lightning that comes to that area, it would end up striking the lightning rod before it hit the tower.
Okay, appreciate that. What is a lightning rod made out of?
It's usually galvanized steel.
Okay, what is the size?
Sometimes
What's the size of that? I know what the height is, it's 10 feet high.
we usually it's in the neighborhood of about a half inch to 5/8 inch rod.
Okay. And that adds an additional 10 feet on top of the cell phone tower.
So according to the FAA, they consider that to be an appurtenance.
Okay. It's my understanding that you didn't approach anyone of First Friends for consent to add that antenna, correct?
It's shown on all our drawings. They visualize that, obviously. We just-
For the second application that we're here on today, no one physically approached First Friends to get consent for that antenna, correct?
I don't know. I
You did.
personally did not.
Okay. So you're unaware of whether or not a Tower Co representative actually approached the First Friends representative?
Probably, I don't know. You're asking me a question I can't answer.
Okay. So you're not aware of any representative from Tower Co approaching the First Friends representative, correct?
I'm not aware.
Are you aware of whether or not Tower Co has authority as an agent to make representations on behalf of First Friends?
You're going to have to ask Talco that. I'm not a representative of Talco. I don't work for Talco. I'm a consultant for it.
And I think, and going back to the testimony before, you stated that you were aware of some negotiations regarding agency language contained in one of the prior drafts of the agreement. Is that
I was
correct?
not involved in the agreement whatsoever. I'm not a real estate agent. I'm not involved in the lease agreement.
Okay. Have you looked at those agreements?
This is the first time I actually saw it. Usually they keep one of those lease agreements confidential. I'm not in a lot of real estate.
Are you aware of whether or not Tower Co has agent authority on behalf of First Friends?
I don't know what you mean by quote-unquote agent authority.
To make representations on behalf of the third subdivision?
Don't know. I'm not a judge.
I have one question.
Go ahead, Mr. Chairman.
Yeah.
Have you ever seen a cell tower located on an electric transmission line?
I have. That's a last-ditch effort, trying to do something. I have seen it done before. It's extremely difficult. It's extremely expensive. And it's something that the wireless industry tries to stay away from.
What voltage of transmit have you seen that location?
Multiples, mostly up around the Cleveland areas where I've seen some.
High voltage?
Oh, yeah, high voltage.
Thank you. Go ahead.
Just a question for either the attorney representing the First Friends or anybody else from First Friends. I heard testimony saying that the church invited the residents from Montebello to meetings, but did they make personal visits to the adjacent homeowners in the residential development?
I do not know that information.
No.
Okay, thank you.
Mr. Chair, I have a couple of questions for Mr. Pitcher. Mr. Pitcher, when you presented the coverage maps that were on the board, and I don't know if you'll need those for this line of questioning, or maybe we could have somebody hand them to you. Yes. I'm looking at plot 1, and we also have plot 2. On both maps, you have a label that says Canton RT43. Am I to assume that that is the location of this proposed tower?
It's just the nomenclature close to where that's going to be located. It's just a label.
Okay. If I'm to read this map, the actual proposed site for the Canton Route 43 tower would be in the next trapezoid immediately to the left of that Canton Route 43 label. Is that correct?
Geez, I'm not sure what you're referring to.
And your label is in a different spot than my label.
This is it right here.
Okay, the label on here is different than the label on my map here.
It's just a label that's folded around on.
Okay, well, see, that's what I'm looking at here, because the map submitted, we have a poor coverage area here that remains unchanged on plot 2 that was submitted.
Understand. They have a need for potentially more than one site in this location is what that results in.
Okay, based on the maps that you submitted to the Planning Commission, there doesn't appear to be any change in the poor coverage. Well, I'm going to say very little change. And once again, I'm referring to the maps that were submitted in the packet, which appear to be different than the ones on your board there. I'm just wondering if you could explain why immediately where the cell tower is, we don't go from adequate to good and from poor to adequate for the bulk of that area.
Part of what they use in the process of coming up with a new search area is they physically drive around with signal receiving equipment in order to be able to measure what they're getting for signal and likewise the capacity. They're two separate issues. Coverage is one, that you're getting signal. Capacity is something when that cell site is overloaded that they have an issue with. So these are coverage related maps, not capacity related maps. So we're only going to see coverage on here. Capacity is another issue that's really hard to define on a map. The only thing that they can use is the drive around data, and I think somebody mentioned before, trouble calls, drop calls, customer complaints. They use a lot of that data in order to be able to summarize these. They find a certain search area for a certain problem that they have. That doesn't mean that they don't have other problems in the areas you can well see on this map that they eventually will have to solve.
So if I could, what is the defined problem that they are trying to solve with this cell tower?
It was my understanding they had a coverage problem and a capacity related problem.
So both a coverage and capacity.
Correct.
And you've indicated that capacity is extremely difficult, maybe if not impossible to map. Is
To
that
show
correct?
on the map anyway without data.
Okay. So, but the change in coverage on the maps that were submitted does not appear to change a whole lot. Is that?
You can see where the white disappears here and disappears back over here. So there are areas that it's helping in coverage, but I think this is probably more of a capacity related issue.
Okay. Is there a reason that the maps there on that display board are different from what was submitted with the packet to the Planning Commission?
Don't know why that might be different. I know I only got one set of plots from Verizon, so I'm not sure why that might be different. If it is, it might just be the label itself. I'm not sure.
Well, there's definite differences in the gaps and coverage areas on the display board you're holding and the maps that were submitted to the Planning Commission. That's all I have.
Okay. Okay, open to the commission in general for our discussion and consideration. I'd like to point out initially that, we're hearing a lot of conflicting stories amongst the parties, some information that we may or may not have seen or need. So if we're tabling this issue until some of those issues can be resolved is an option. The other are, let's proceed, and we've got two things to discuss and vote on. One is to permit a conditional use for a cell tower on this site. And then secondly, consideration and review of the site plan as submitted with that. I'll open it up to discussion and questions of the commission.
Mr. Chairman, if I may, before they begin deliberations, this is, I think, just as much important for members of our commission as the members of our audience that have been here for a couple hours. I'm not sure exactly where we're at, 2.5 hours that we've been here, and I think maybe one or two may have left, but I think they've been diligent and come in and expressed their concerns, as well as those that have come in with witnesses and presented evidence. And it's important that we get across that the commission, because this is an adjudicatory hearing, it's an issue determining a matter of rights and the ability to exercise those rights, that you understand that the commission, in some instances, it may not consider some of the things that were raised as comments. If your comments were your feelings, your emotions, your concerns, although certainly the commission can empathize and put themselves in that place, and some of them may live near where there's a several-year tower, they can empathize. But if indeed you've not presented what the courts deem as substantial evidence for what you propose, then those issues may not be considered. And federal law actually sets guidelines for planning commissions around the country for things that they may consider and things that they may not. One of the speakers mentioned the issues that if this tower is one of the ones that within the radio frequency parameters that's approved by the FCC, it's mandated that they may not consider environmental concerns that residents may bring unless they bring in evidence to contradict those types of things. And unfortunately this evening we didn't see that. And so there's a couple things that I want the commission members to understand. It's a little different with the cell tower and the federal act that we have to comply with, that the U.S. Supreme Court, in an opinion just within this last year, has mandated that if there is a denial of a cell phone application, that the locality that was behind that denial must give its reasons in writing, and sufficient reasons so the court may ascertain how you made judgment calls, how you weighed evidence, how you looked at credibility between speakers and exhibits. And so if the issue is, if there's a motion, say, to deny, and I don't want to be presumptuous, I just want to make sure that you're aware of that with a denial, that's where the Supreme Court has come in and said, because there's a period within the next 30 days after that denial, that the applicant may appeal that issue. That's why they require, we've got to know the reasons for this appeal. And so there's a requirement that unless you give a detailed explanation in your minutes, and your minutes are provided almost simultaneously with your decision, the Supreme Court recommends in a denial that the commission provide perhaps a brief letter stating the reasons for that denial, and certainly with sufficient information based on substantial evidence to support that. In that denial, there's one other consideration, and this comes from our Sixth Circuit Court of Appeals, which is our federal Court of Appeals, and that can come into play because this is a federal act that's under review and provides these parameters. And it provides that if there is a denial, that in an appeal, one of the issues that can be raised is that the locality is trying to protect this area and ban these types of towers because of perhaps this type of neighborhood, or that they have plenty of residents and area that come out and express their concerns. So the Sixth Circuit Court of Appeals has set a two-part test that if you're going to deny it, and this reaches in an appeal, that the applicant, the tower company in this sense, would have to have demonstrated with substantial evidence to this commission, first, demonstrated a significant gap in coverage with evidence, and it states various ways that it can support this. And it suggested one of those was this propagation map. And now we may have an issue of what was presented to the commission or what may be an exhibit. So we want to make sure that these exhibits that are presented this evening are saved, captured in some way. So if this is appealed, but they also talk about drive test data to demonstrate the significant gap in coverage, and and engineers report similarly, and as well as, that's why I did ask about customers' complaints. And was this presented to you as someone's comment, or did in your mind actually receive evidence of customer complaints about this significant gap? If you reach that, your second prong is that there's this requirement, and I asked each of these questions. The second part is the requirement to show your good faith effort as the applicant, that you looked at other possibilities to perhaps place this tower that would have a lesser impact in the area for the folks that have these concerns. And I don't know that I saw that and presented as evidence. There were some comments from a witness that said this is the only appropriate area given the manner of how North Canton and Canton are set up, and there's really no other appropriate place to put the tower. I've not heard of any other propositions to other locations and so forth. We did have Councilman Mack that was here and talked about the water tower, and so there's been a discussion of whether or not it's appropriate. I have heard comments that it is difficult when you do paint a water tower, and I know that it is expensive. We painted a tower about 3 or 4 years ago. It was pretty expensive even at that time. But have we been presented evidence to us that placing it on the tower, a water tower, to co-locate with others that are already there, that whether or not painting that tower is going to drop that coverage, and for a period of time there is not only going to be a gap, but there's going to be no coverage. So I just want to make sure that before you deliberate and debate, that you put those into consideration, because when you get to the point of voting, if it is if this is an acceptance, you don't have these requirements of substantiating these things in an appeal. They'll always come back to whether or not you had evidence to support that. But it is crystal clear in the courts of appeal that a denial requires those two things. That certainly the first, that it is in writing, you give the reasons, and in an appeal for that, you must have demonstrated, that you didn't have substantial evidence to support the significant gap in coverage, and that good faith effort was made to place that tower or that antenna in a location that would be less of an impact on the residents. So I thank you for, I know it's a lot to kind of digest there, but I want to make sure that we don't want to come back from a court decision saying you kind of missed something. So thank you for adding a little bit more to that, just in the hopes that we get that covered, and the judge doesn't say, perhaps it's going to come back to you for one other thing. So thank you for your patience, and thank you for those that came this evening, and your patience for me to try to kind of wrap it up, but it takes some additional time.
Ask it, give a commission question, comments, discussion.
I think at this point, Mr. Chair, one of the, in reviewing the plans and things of that nature, there's really only a couple of things that I have questions potentially about, whether they've been resolved or not, I'm still considering. But with respect to the site plan, meeting the landscaping, height, setback, structure ordinances, all of that kind of stuff. In my opinion, that I feel that it meets all of that stuff. So I think that doesn't necessarily concern me. There's two things that came up. Potentially the detention basin, but even there we heard testimony. Well, number one, we have a memo from the city engineer indicating that the runoff, the impervious surface is negligible on this, and also the testimony by Mr. Barnes has indicated that really there's been no calculations done to show that that's going to impact that. The other is just the coverage areas, and recognizing that there's different types of coverages. Some can be mapped, some cannot. But I do have a couple of concerns that the exhibits presented to the Planning Commission and the exhibits presented by the applicant tonight didn't necessarily match up. So those are some of the concerns I have. But I would like to hear what members may feel.
Anyone? Questions, comments?
I agree with him on part of the site plan being met as far as setbacks and all that. We had approved this once before, and it came back because we stepped out of our bounds or whatever. We approved something that should have been a zoning
Well, the
issue.
variance.
Yeah.
There are no variances with this issue, no.
Just the conditional use.
I do have a question for Mr. Fox about procedurally. If we as a commission request additional information regarding the coverage maps and additional information regarding that, is that prejudicial to other members that have been present tonight and given testimony? Or would we be within our bounds as a planning commission to table it, request additional information to help us in our decision?
Well, I believe if you wish to table this, that you also open it up for anyone else, because there's other, residents that have come in, and, we were clear with them, your duty is to appear and present your evidence. So my recommendation is to make the decision based on what was presented to you here. This has been continued one other time, and offering that for someone to shore that up, it's only fair for everyone else to do that. And I think everyone that was involved this evening was, I think, even the ones that may have stated they didn't receive the notice that they believe they should have, because we've been through this one other time. There were meetings with the church. There was no mistake that North Canton Planning Commission was having a conditional use hearing this evening regarding Tower Company. The repository reported it. Every attorney that's here this evening representing the city of Canton, Tower Co., Montebello Homeowners Association have contacted me, asked questions about the process and so forth, and one of those that didn't, I made sure I contacted others and that they were each on the same page. So everyone had the opportunity to come and present their evidence, and based on that, I think it's only fair that the commission have the obligation to, it's almost to me a go, no-go. Your obligation is, did you receive substantial evidence that they not only met our requirements for a conditional use and the placement of a cell tower, as well as a site plan, and did they meet their duty as far as demonstrating that there's a significant gap and that they made the good faith effort to look for other locations. And if they've not met that burden, then I believe then your decision is in the negative simply because they've not met that burden.
So we need to meet that burden to approve it and to deny it, or just to deny it?
To deny it.
That
See,
they have not made it, if it's approved, there's nothing in the record that necessarily has to show that substantial evidence was submitted.
Correct. If that is appealed, then the Court of Appeals will look for, did you have substantial evidence to approve that? And simply the court is going to look at, was there reasonable, substantial? Did they show you something other than their concerns or their feelings about this? There's plenty of folks, and I think for good reason, said, a cell tower, I don't want to look at it in my backyard. And you can understand and empathize with that. But, the issues of providing evidence.
What are you supposed to provide?
The issue of providing evidence, that was their burden. I believe many of those in the community appropriately so sought legal counsel, which included First Friends Church, Montebello Homeowners Association, the City of Canton. They used attorneys. They sought out the evidence that they would need to prove the burdens that they had to demonstrate before this commission. But I can understand that the concern that if you approve it, then you don't need to demonstrate that two-part test. And the reason is the Sixth Circuit has determined that, on those denials to overturn that's the burden for the applicant. You need to show to overcome concerned citizens' issues and so forth with their property values and so forth. To overcome those, you need to demonstrate the gap, that it actually needs to be there to provide this important utility, and that you've at least demonstrated that you looked at other areas and presented evidence that you made the attempt to ameliorate these issues that the residents have and place it in another location. And if you don't have that evidence before you, then that's what I think weighs in the concern that the issue may be a denial, because the concern is all you have is a coverage map. And the coverage map, that was the issue of how are you demonstrating what the court considers a significant gap, and how you demonstrate that. With evidence, we have these coverage maps, and you may have concerns of whether or not that demonstrates significant loss of coverage, and whether or not you've been presented with evidence of dropped calls, the constant busy signal, and those types of issues in forming your decision.
Eric, question, the original application, was it signed by Power Company or Great Friends?
It was signed by Mr. Pitcher.
Pardon?
The original one was signed by Mr. Pitcher.
Thank you. Other questions? I would suggest that any motion that we make it in a positive vein, we either yea or nay.